Okay, perhaps we should get started. I'm Marg and Jerry. First, I'm delighted to see you here. The binders that you have, I believe there are 2 more papers that will be added to it later. And the 6-minute series has been very successful, and I'm sure that you'll have a successful day here as well. It gives me pleasure to introduce Andrea Davidson, the chair of today's program, who's a specialist in personal injury, wrongful dismissal, and estate litigation with Fuderman and Fuderman. She graduated from McGill, and she wouldn't tell me a thing about her childhood, and she asked me to leave out most of the rest. So Andrea, hope you have a very good day.
Thanks very much. The 2 papers that are missing are Leilah, Edroos, and Gina Brannon. I'm not sure when they're going to be available. Hopefully Leilah's at the coffee break. Gina is the last speaker, is in Hamilton in court, and then coming screaming in here, probably with her paper. So you're going to have to find those 2 papers before you leave, and I apologize on their behalf. Thank you for attending. The idea behind this program is to provide an update on excuse me, a few areas of civil litigation, and to fill in some blanks in some areas such as electronic filing, the problems they're having, some advice, the children's lawyer, if you've never had to deal with a children's lawyer, just something that you can learn, take away, hopefully use in your practice, and have the binder to refer to. The speakers are all very busy litigators who have found the time to prepare papers and be here this morning. A number of the speakers are personal friends of mine, and those of them are here. I want to thank them for helping me out today. Some lawyers are on the other side of cases with me, and I used it as a threat. I said, this is the beginning. I've invited you to speak at this, and who knows what comes next. So let's get this case resolved. I should also inform you that you've been slightly misled. It's called the 6-minute guide, so you're expecting the speakers to speak for 6 minutes. But some people took on 2 aspects of a topic. For example, Peter Daley will be speaking on security for costs from both the plaintiff and the defense perspective, so he gets 12 minutes. So if you're watching your watch, you've been misled. They're not all 6 minutes. There will be time for questions at the end of the first group of speakers before the coffee break, and then at the end. So I'd ask you to save your questions, but there will be time for that. So we will start the program. The first speaker is Lois Roberts on the topic of really, when the client first comes into your office, a checklist of what you have to make sure you convey. Ms. Roberts was called to the bar in 1987. She's a partner with the firm of Genet Murray. She practices law in English and French, which I find to be most impressive. And the areas that she specializes in are professional liability, commercial litigation, employment law, and human rights.
Thank you. As Andrea just said, I'm going to speak about the initial client meeting. I provided you with a checklist of essential points to review with your client. That's at tab 1. I think the checklist is pretty straightforward. What I'd like to do in the minutes allotted to me is just review certain points about each of the points set out in the checklist that might not be completely self-evident. As all of you know, the initial client meeting is the opportunity you have to set the parameters for your relationship with your client. It's the first step in managing your client relationship. It's also the opportunity for gathering of information and also the opportunity to raise certain matters which for some reason lawyers find difficult. That is, how much it's going to cost you to pay for my services, what are my hourly rates, that sort of thing. This is the opportunity to get all that sort of thing out on the table, and the purpose of it all is to make sure that the client has realistic expectations of what you're going to do for the client and what's going to happen in the lawsuit, as best as you can tell from the beginning. Now, the reason that this is important, just before I get into the checklist, is if you look at, I don't know if any of you have gone to the website that LPIC, Lawyers Professional Indemnity Company, puts out, the Practice Pro. It's quite interesting. But anyway, one interesting statistic is that the leading cause, according to the statistics compiled by LPIC, the the majority of errors that result in claims come from the failure of the lawyer-client relationship. And more particularly, something like more than 60% of claims reported are linked to errors such as failure to follow instructions and conflicts of interest. And that's why it's so important from the word go that you set out, first of all, whether you can act for the client, and we're going to go into that in a second. And second of all, what is it the client is instructing you to do, and what is it the client is not instructing you to do? And we'll get into that in terms of the scope of the retainer. But just dealing with conflicts, that's pretty straightforward. Can you act for this client? Are you already acting for someone, for the party that this client wants you to sue? And the most important point of this, that's straightforward, but the most important point of this is, when do you check for this conflict? Do you check for it halfway through the client meeting? No. You have to do it right off the bat, really almost before the client comes into your office. It's the most practical way, on a phone call or whatever, however you're introduced to that client, because if you wait until the client comes in and goes through half of the case with you, you are then running the risk of putting yourself into a conflict position. Because if you get information from the client meeting before checking for a conflict that you otherwise wouldn't have obtained, you are then in a conflict position. You can't act for your client, the former client or the present client. So that's why it's important to check for a conflict before you do anything. And checking for a conflict means that you check out, and that's why it can take some time, you check out, in the case of a corporation that the new client wants to sue, who are the shareholders, directors, officers, to help you identify the party that you've been asked to litigate against, and that you might already be acting for, especially if it's a numbered company, 12364 Ontario Limited. You can't necessarily tell by the name, that kind of corporate name, whether or not you're already acting for that company. So that's a question of when you do that. All right, so you check for the conflict, you don't have a conflict. You meet with the client, you want to set out and discuss with the client, what is it you're asking me to do? And why I say it's important to indicate what it is you're not being asked to do is because while you're talking to the client and gathering information to find out what it is you're supposed to do for this client, the client may or may not understand the litigation process. The client may or may not understand what it is he or she wants you to do. The client, more often than not, will come in and say, I've been just thrown out of my job, do something for me. What can I do? What remedies am I entitled to? And that's an example to say that not only do you have to advise in terms of specific causes of action that the client may or may not identify, that is wrongful dismissal action or whatever, but you also have to identify for a client causes of action that are related or potential claims that are related. For example, in the case of a wrongful dismissal action, the client might also have the right to launch a human rights complaint. So there are items like, now the client might not want you to act on the human rights complaint, but you at least have to raise it with the client to see if that client wants you to act or not act. And then going into the next point with respect to the scope of the retainer, the importance of that, of course, is to raise potential limitation periods. Because, for example, in the case of a human rights complaint, you really have to launch it 6 months after for example, if you lose your job, after you lose your job, termination of employment, that sort of thing. So there's specific limitation periods that apply. And again, you think, well, in the case of wrongful dismissal, okay, I can see in terms of specialized cases that we're all worried about, a municipality knows of 7 days, that sort of thing. But when you have a 6-year limitation period, really. But don't forget, you might have a client walking in your door that's waited 2 or 3 years before he or she has decided that they want to retain their lawyer or start an action. So you always have to narrow that down quickly too, and advise the client that, you only have X number of days, if that's applicable, or weeks or years or whatever, to start this action or give notice. The other thing might be is that the client might not make up his or her mind whether or not he wants you to act right away. So that's why it's important to raise the limitation period or potential limitation period right away. Well, let me think about it. I definitely want you to sue on my wrongful dismissal claim, but I don't know if I want to start a human rights complaint, or in the case of a personal injury, I don't know if I want to sue the municipality, I want to sue this person or whatever. They still have to be aware that, well, okay, fine, but you have to tell me within X number of days, or you're aware that if you don't tell me, you won't be able to sue. You won't be able to bring this claim. So that's why those kinds of things are important to raise right off the bat. Once you, in the initial client meeting, again, it might not be completely possible to determine the scope of the retainer right away. You might have to do additional research. You might have to do something else to determine whether or not there is a cause of action. So again, the scope of the retainer might sort of evolve over time, and that's fine, just as long as you outline to a client at each step what it is you're being asked to do and not being asked to do. In the client meeting, you then go through the review of procedural steps. You don't have to go into excruciating detail about, starting pleadings and we do this and do that, but you have to do a run through of what the client can expect in any given proceeding. I'm using the example of an action right now, just for ease of reference. You should generally say, well, these are the steps of the action. You have to go through the pleadings, and then there's the discovery stage, and there's this and there's that, and the pretrial conference, and there may be motions, and we might get to, things happen, we do a trial, and then afterwards there's the collection process. So you go through these stages briefly because it's part of the information gathering process too, and also part of the process going back to the beginning of who is going to give you instructions and from whom are you going to get information and documents which will permit you to do all of this. So this is all sort of a fluid process that permits you to gather all this information. As part of the review of the procedural steps, you're going to ascertain from them, well, is this an action that I start in the small claims court? Is this something I'm going to start in federal court? If it's in the Superior Court of Justice, is this something that should be started under the simplified procedure? And you'll see as one of the appendices in Appendix A, I set out, really I just copied from the rules 7602 and 7601, really when can you start something under, or must you start something under the simplified procedure, and when is something excluded? And it's pretty straightforward because it basically deals with monetary limits. So that if you have a claim that's $25,000 or less, excluding interest and costs, and this is the interesting thing, maybe not so interesting, but it's an important issue that for determining whether you're going under simplified procedure, is that it can be a combination of monetary amount of the claim and then value of the property at the time that you're commencing the action. So that's what you're looking at. Is it together or separately $25,000? Either you're asking for $25,000, you're seeking return of property or the value of property worth $25,000 at that time, or it's a mixture of money and property worth $25,000 or less. And that's the exercise you go through. The same thing as if you have multiple plaintiffs. Each of their separate claims, unless they own it, the property together, it's a joint claim, each of their separate claims meets this criterion, that is $25,000 or under. Then in my second paragraph, I set out the types of actions in respect of which the simplified procedure does not apply. And actions commenced before March 11th, 1996, except with the parties file a consent. But again, don't forget, even with actions commenced before March 11th where the parties consent, those actions still have to meet the criteria that I've set out under paragraph 1, the $25,000 or less. But then you see actions under the Class Proceedings Act, Construction Lien Act, divorce actions, which are Rule 69, and then family law proceedings, Rule 70. The simplified procedure just does not apply to those. So that's your checklist in determining, okay, is it simplified procedure? And when we get into the issue of cost, that becomes relevant to determine with a client. Then the other thing you might want to determine is this a matter which really should be on the commercial list? And then I've set out, I won't go through it in great detail, you can all read it, it's pretty straightforward. In Appendix B, the types of matters that can be on the commercial list. Again, with respect to this, why should you start something? Why do you have to start something under a particular court or simplified procedure because of subject matter? Or when do you want to start something or might want to start something on the commercial list? It really gets into the question of management of the action. That is something on the commercial list. You're dealing with something, presumably you have a roster of judges that have certain expertise. The action can be managed more effectively. There's time limits you can you can have to push the matter along, and there's all sorts of reasons why you might want to start under the commercial list. In terms of time limits, getting into that, as I say, I've alluded to that in certain, you have to go through time limits with your client. That is, once we start an action, depending on whether it's case managed or not, or whether it's under the simplified procedure, or whether it's on the commercial list, there may or may not be certain specific time limits that are more stringent than others, or the regular time limits under the rules. So the client knows that if I need some information from you, once we start this, you know, we have to get our affidavit of documents in by this date, or we have to do this by this date. So I have to have someone I can speak to, get information from. You can't just sit back and think, okay, I can start it, but then I don't have to do anything. So again, it's part of setting the client's expectations. They have to know what's expected of them. They don't just give you the file and then sit back and wait for the whole thing to unfold. It's an ongoing process where you need active participation from your client, and your client should understand that. I mean, even into the discovery process, as unbelievable as it may seem, or if you're dealing with an application, some clients don't appreciate that they might have to give evidence before trial, and that what the discovery process is all about and what they have to reveal about themselves. For example, in a personal injury action, they might not appreciate that they have to reveal, for the most part, or may have to reveal all of their past medical history. This might make a difference in terms of how they want to proceed in the action, or whether they want to proceed at all, but this is information that they need to know. So again, as you're going through the stages of the proceedings, the time limits, that sort of thing, it's information you're giving them, you're setting their expectations, they know what they have to do. Costs, important aspect. Explaining to a client, again, I've broken this up into sort of costs of a proceeding, the scale of costs, party and party basis versus solicitor and client costs. Some clients may think that they get all their costs back if they're successful at the end of the day. We know that's not true. Even on a solicitor and client basis, you only get a percentage, maybe 80–85% of your actual costs, and a client has to understand that. Second, there are certain specific cost sanctions for failing to do certain things. For example, going back to the simplified procedure, if you fail to bring an action within the simplified procedure, which you should have, then there are certain cost sanctions, and you should review those with your clients. The cost consequences of delivering an offer to settle or failing to accept an offer to settle should be reviewed, and other cost consequences. The general cost of an action, how much, as best you can describe conservatively, you can expect an action to cost in different stages. And make it clear to your client you're going to have to review that in the course of the proceedings. Disbursements. A lot of clients and lawyers forget about the main disbursements that are in an action. And they go through, you have to go through expert fees, cost of the discovery, cost of the transcripts, that sort of thing, so the client understands. Finally, your hourly rate. How much you're going to charge. How much it's going to cost. Who else is going to work on that file? Are the hourly rates going to go up? That sort of thing. This all goes into doing a cost-benefit analysis for your client, which should be done at the very beginning, even if it's a rough one, and at every stage of the proceeding, so the client understands what it is that the client is getting into. The client might think, I have a great case, it's wonderful, it's great. It is great or whatever, but it's going to cost you X dollars to do it. Is it really worth it to you at the end of the day? A lot of clients say, well, it's the principal. At the end of the day, when they're looking at a huge bill, the principal is not so important. So always do a cost-benefit analysis. Finally, confirm all of this in writing. Client might be sophisticated or not, but might not be able to remember all of this. You confirm the retainer in writing, you confirm instructions, you confirm any information you want from the client, remind the client of things they have to bring to you. And again, this should be done whether or not you end up acting for the client or not. Specifically, if you don't act for the client, because you have to remind them that you have not retained me, but you should be aware of certain limitation periods. Finally, I just wanted to say that in terms of this checklist, this is a checklist that I suggest for the initial client meeting, but obviously it can be used and should be used throughout every stage of the proceeding and should be updated as you go along. And that's, if you do that, your relationship will be smooth, expectations will be met, or in the worst case scenario, the termination of the relationship will be smoother.
Thank you very very much, Lois. That was very comprehensive. I think I just wanted to add one thing, and I think it was, she spoke of the review of the steps in the litigation. I act, for the most part, for very unsophisticated clients, and I think another important thing is to tell them how long it's going to take. I get a call after 6 months. What are you doing wrong? Why isn't my case at trial yet? And I just obviously haven't spent enough time explaining how long it's going to take me to get it to discovery, to get it. And I have a senior partner who I often meet with clients, and he always tells them way longer than I think it's going to take. And, you know, it's not a bad strategy. So when you bring it in, you know, you get them to the pretrial earlier than they'd ever thought. They think you've done a good job. I just cringe when he says this case could take 3 to 4 years. And I'm sure if any judges were sitting here, they'd say, you shouldn't be telling clients that. But then when you sort of bring it in under 2 years, they think you really did a good job. I'm not suggesting it's sneaky, but sometimes, you know, the lawyer on the other side takes a maternity leave or gets sick, and it just seems to me for reasons beyond my control, often the cases do take longer than I anticipate. But clients, I didn't used to tell them how long it was going to take because I thought they'd go running out of my office, but I think you really have to. And the other thing that is in Lois's information is collection. I mean, I think that's where I have, when I was a young lawyer, really fell down and not telling them, yes, you have a good case, but we really have to look at, are we ever going to collect on this claim? We can move on to our next topic, which is an update on the practical aspects of solicitor-client privilege. Our speaker is Mr. William J. Burden, a partner at Castles, Brock & Blackwell. He was admitted to the bar in 1976. He practices in the areas of commercial litigation. He's most recently been involved in the litigation arising out of the restructuring of companies including Olympia and York, Central Guarantee Trust Co., and Royal Trust Co. He's written articles and delivered papers in the area of debtor-creditor, and he's a former member of the executive of the Ontario Insolvency Section of the Canadian Bar Association.
This area, needless to say, is a very picky area, solicitor and client area, in the area of litigation privilege, solicitor and client privilege and litigation privilege, and it involves sort of looking at the case law and then trying to juxtapose it with the rules of civil procedure. And so it's necessarily a time-consuming and complex task. You have to read, you obviously have to spend time reading the case law. One of the interesting cases that has come out in this area recently is the General Accident Assurance Company and Cruz case. The Ontario Court of Appeal finally recently has sat down and gone through what they understand, and Justice Carthy was on that panel, and of course he's always been a man very versed in the rules of civil procedure. So he was on that panel, and he discussed, along with to Justice Rosenberg and Justice Doherty, the issue of solicitor and client privilege, generally speaking, and as well the issue of litigation privilege, generally speaking. And it's something every practitioner should take the time to read the case. I know you do. You're probably all familiar with it, but to understand how it works day to day in your practice is fundamental, and it certainly impacts on every discovery that you sit in on. Is where can you claim litigation privilege with respect to both documents, and where can you claim litigation privilege with respect to disclosure of the names of witnesses, addresses of witnesses, and the gist of their evidence. So that's the area we're talking about here. So you can't read in this area enough. You have to understand it in order to play with the rules. It's become too complex out there, as they say, because we have a whole body of case law, and we've got the rules of civil procedure, and we've got some archaic law with respect to litigation privilege. So it almost has become too complex, and it reminds me of a quick anecdote, that story. I guess in a 6-minute lecture you shouldn't have a story, but they used to have the assizes, of course. The Supreme Court judges used to travel around the province, but they were all based here in Toronto. And they were the sort of the peers, and they had great status, but they would go up to Thunder Bay and sit there for 2 weeks and hear cases. And a true story, one of the judges up there, 2 counsel were really going at it, and he just couldn't believe it. He's into the 3rd day of trial, and he finally looks down at both counsel and says, don't you people know anything at all about the rules of civil procedure? Don't you know anything at all about practice and evidentiary issues? And within just 2 minutes, one of them shot back and said, west of Thunder Bay, my lord, we don't even go by the 10 Commandments. but it's a interesting area, as I said, and some of the basic principles, if you turn to the paper, and the issues are set out on they're numbered 1 through 4, I guess 1 through 5. Solicitor and client privilege is limited to confidential communications, so that, you know, the whole idea of solicitor and client privilege is based on a relationship. That is, you're protecting the relationship and the confidential communications of the client. How that applies to a third party is the interesting issue. Everybody can sort of answer in the area of solicitor and client privilege. Everybody sort of, you know, we know that's a protected area. It's rare a court is going to get involved in ordering disclosure in that area. But third parties, and that's what the Cruz case involved. That is a third party adjuster, independent contractor, who was dealing with the lawyer. When are his communications with the lawyer and his reports privileged? And that issue, of course, is what determines that. And again, that's the fuzzy area, is was the communication between the third-party adjuster and the lawyer, in essence, essential to the solicitor and client relationship? Was he communicating on the basis of really on behalf of the client? It's a bit of a tricky area. The court was a bit divided on the issue, but that's the essence of what you're going to get into in terms of solicitor and client privilege. It's in the third party area that I think you're going to have the issues that arise most often. Litigation privilege is the one that's the more difficult of all of the areas. And litigation privilege, as opposed to solicitor and client privilege, is designed to, solicitor and client protects the relationship. Litigation privilege protects the process. It's designed to make the adversarial process, the litigation process, fair. What the court has finally determined for us all is that in order for a document or a piece of evidence to be privileged under litigation privilege as part of the solicitor's work product, etc., it has to be prepared for the dominant purpose, with the dominant purpose of litigation in mind, or contemplated litigation. And that's at least we're not into the substantial purpose test anymore, which was even more murky. Now it's a dominant purpose. So to satisfy that is a much more difficult test, and again, it's going to lead to more disclosure. And clearly the court was siding on the area of disclosure. In terms of the issue of contemplated litigation is again a difficult area. You know, that's a factual thing that's going to be argued every time you're trying to keep a document out. Was litigation really contemplated at the time? If litigation is ongoing, it's easy, but that's not where the situation arises. It's usually in the context of whether there's contemplated litigation. The other area, tricky area, is where work is just the solicitor's work product. When can you deny answering questions on discovery about what documents have come into your possession by your own work efforts? In other words, you go out and you interview people, or you go out and gather up documents. That would be ordinarily in the old days, in the days where it was just what you would call, I guess, a true fight, a true adversarial system, whereas now it's a full disclosure system. In the old system, you wouldn't be disclosing that. You'd be saying it's part of your litigation product. You did it. You don't have to disclose it. But the interesting area, and all of the judges recognize this when you read that case, and again, I'm not going to take you through it because you can read it on your own and get it. But the interesting thing about the case is the judges and Justice Carthy was very strong that the rules of civil procedure interact with litigation privilege. And of course, the rules of civil procedure greatly emasculate litigation privilege. And a specific example of that, of course, is in the areas of, in the case law with respect to the, you have to answer the names. There's a specific rule, of course, dealing with the names and addresses of witnesses. Well, the case law has evolved to the point where we have a series of cases that has led to the point not only names and addresses of witnesses have to be given that you've interviewed, but the substance of what they've said probably has to be released. There's a good argument to be made based on the case law that You don't have to disclose, obviously, the actual notes that you've made of your interview, but you would have to disclose probably the substance of what's in those notes. The case law, there's a recent case with respect, most often an insurance adjuster again situation, surveillance, the videotape by the court didn't have, the court compromised in the area and said the videotape didn't have to be produced, but that all of the background facts, the substance of what was observed had to be released. So the distinction that the court was trying to protect was litigation privilege. The product of your work, the videotape, was in fact protected, but you still had to tell the other side on discovery what the notes revealed, what was on the tape as well, the factual underpinnings of the tape. So I'm not sure there is a real distinction. I think that what's happened is that for all intents and purposes, litigation privilege, as we used to know it, is going to be a difficult concept to maintain. It's been, for all intents and purposes, the rules of civil procedure and the overwhelming desire for full disclosure in a fair system, a fair adversarial system, prevails. And the rules which require you to disclose that. You also, as you recall, under the rules, you have a duty of continuing disclosure. If facts come to your attention after the discovery, you have to disclose that. There's a specific rule that you have to file a supplementary affidavit of documents if documents come into your possession. So it is one of those difficult situations, because conceptually you can understand this. One lawyer does all the work. He goes out and interviews 12 people. And on discovery, if he does this all prior to discovery, he's got himself into a jam on what he says or what he doesn't say on discovery. And it is it's a landmine, as you can well appreciate. There's going to be issues on ethics, issues on disclosure, but you're going to be put to the test by counsel who's really into it in terms of the privilege aspect and the rules on disclosure. And in terms of where that leads, how much research you should be doing prior to discovery, or how much interviewing prior to discovery is one issue, and then certainly the continuing disclosure prior to trial creates your own dilemmas. What happens if you interview a witness and it becomes clearly a situation where the information you've obtained is adverse in interest to your client? You're into that difficult situation prior to trial. You've got a continuing obligation under the rules to disclose. You might obtain some documents from that witness which are adverse. You've got an obligation to file a supplementary affidavit of documents. These are all rules which practitioners grapple with every day. There's an ethical component to it. But by and large, it does lead to your own style of practice. What do you do when you're interviewing a witness and suddenly you think you're going to get some adverse information? Do you stop the interview? Do you just leave it alone and say that's the end of it? I won't get into this. Those are the issues that come up from this particular case, and as I say, the interplay between litigation privilege and the rules of civil procedure is where you're going to get into it, and it's the solicitor's work product, where you yourselves are going out on a daily basis and investigating your own cases. When is there an obligation to disclose? And I can only say to you that the rules of civil procedure have been certainly dominate in this area according to the Court of Appeal, and they're very clear on that, so that you want to know on those continuing obligations of disclosure that you're into a difficult area if you're trying to maintain litigation privilege. I think for all intents and purposes, litigation privilege is as I say, very emasculated under the present Ontario rules.
Thank you very much. It's true. I think the point that you hit on at the end, when I have personally interviewed a witness and something comes up, the other side discovery goes first and they disclose what a witness has said, and I know I've spoken to them, that isn't exactly what they say, and I can just see myself being a witness at trial and losing this file and trying to figure out what to do. And obviously if I get my law clerk to do the interview, I haven't accomplished anything, but I've got knowledge, and it's not exactly what the other guy's saying, and am I going to end up a witness? So it's something that you really have to, as he said, look very hard at when you do, what you disclose, and think about before you go into discovery, what do I have to disclose? It's getting more and more difficult to practice in this area because I think the courts are holding us to a higher and higher standard that lawyers who started practicing 30 years ago would have gone, what are you talking about? Anyhow, our next speaker is Peter Daley on the topic of security for costs. He's agreed to do both sides from the plaintiff's perspective when a motion's brought and from the defense side. Peter was called to the bar in 1976. He's with the firm of Miller Thompson. He's the co-chair of their insurance practice group. He practices in the areas of professional negligence, products liability, life and disability, and tort litigation. Past director of the insurance section of the Canadian Bar. He's appeared as counsel at trial throughout Ontario as well as the Court of Appeal and Supreme Court of Canada. On a personal note, Peter is one of the people who I asked him to do this and said that, you know, this was just a beginning of a series of things I was going to ask him to do. And I got an offer to settle, and today when he arrived, he said, "Have you got my check yet?"
It's in the mail.
That's what you said.
Thanks, Andrea. I propose to do what I'll call a helicopter overview of the paper I've given you. Regrettably, I guess I've selected one of the drier and more technical topics on the agenda for today. And for that reason, what I'm going to do in reviewing the paper that you have in front of you is highlight the hot spots or the issues I think are important, or at least currently are important to the practitioner on a day-to-day basis. At the back of the paper, you'll find a substantial amount of notes and references that my associate helped me put together. And I think by large part, a lot of them are fairly current. They're cases that are reported in the last year or so and as recently as this year. I think when you have time to review the paper, they may be of some assistance to you in your day-to-day practice. The whole question of security for costs is a significant piece of our day-to-day life as litigators. And long ago, a prominent barrister was concluding a trial in front of the court, and he was asked by the judge what type of relief he was looking for. And his simple response was he wanted justice with costs, my lord. And that is very true today. We have a unique system in Ontario. If any of you have litigated in the United States or had cases in the United States, you'll know that U.S. litigants, U.S. insurers are somewhat surprised that we have a cost system at all. Our trend, of course, came from Britain. In the United States, most states don't have costs. So costs, the collection of costs, and the procedure associated with securing costs represent a significant part of our role as counsel in litigation in Ontario. The process of securing costs and protecting your client's interests as far as the collection of costs is concerned is largely set out in Rule 56. I haven't quoted the whole rule in my paper, but I'm sure you all have a copy of the rules and you can review the pertinent sections. I reference the sections as they relate to various plaintiffs or claimants or parties as they're referred to. You'll see the layout of the paper from that perspective. Before I get into some of the more technical issues, you must all be aware that counsel, particularly for defendant or respondent in a proceeding, has a duty to ensure that the client is fully aware of the whole concept of security for costs. If you have an opponent who is in the out of the jurisdiction largely, or in the jurisdiction and maybe impecunious or difficult defendant to collect from, you should cover those issues with your client if you're aware that that is going to be a concern during the course of the litigation. The last thing you want to do is proceed to trial in a case and have a great success and then have to tell the client that you as the defendant or respondent are unable to collect the costs because of some technical reason that could have been protected by way of an order for security for costs during the course of the litigation. Rule 56, as I say, is the rule that drives all this, and Rule 56 has a fairly broad discretion contained in it. In the rule, the opening wording talks about an award of costs in situations such that the award is just or the determination is just. And the courts have used that that language often as sort of an escape route to expand or limit the rights to costs or security for costs. So when you read the cases that are referenced in the paper, you'll see that this concept comes up regularly and quite frequently. I'm going to talk in a moment about impecuniosity and what that means, and that is one of the areas where the courts have considered the whole concept of what is just. Clearly the courts don't want to take actions away from people because they can't post security for costs, and that's one of the issues that's dealt with when one deals with impecuniosity. The most common situation you face where you're dealing with Rule 56 is a non-resident plaintiff, and the onus on a defendant on an application for security for costs is firstly to show the plaintiff is a non-resident, and if that is the case and it's undisputed, the onus would then shift to the plaintiff to demonstrate he or she, or the corporation, if it's a corporate plaintiff, has assets within the jurisdiction. That gets into, obviously, the exchange of presumably substantial documentation and information concerning the financial wherewithal of the party. One matter I would draw to your attention is the question of determining whether or not the plaintiff is in fact a non-resident. Oftentimes the pleadings are vague or don't specifically state where a plaintiff resides. And under Rule 5602, there's a procedure set out there where you can serve a demand letter upon the plaintiff demanding that he advise you as to the residency of the plaintiff, and failing a response, you can move to have the action stayed or dismissed. In any case where you have concerns, particularly in a corporate context, if you have a corporate plaintiff and you're not sure too much about the background of that plaintiff, you may be smart to serve that kind of demand to clear that issue right up front. And again, this is something you don't want to have to account to your client for later in the event you fail to do this. Dealing with the non-residency issues, again, a couple of the significant issues or points are that temporary absence from the jurisdiction by a party does not constitute non-residence. Conversely, residence must be real and not temporary. And again, I'm not going to take you through the cases that analyze these issues, but there's a high degree of flexibility in determining whether someone is resident or non-resident, both in the corporate context and in the individual context, or the single plaintiff. A non-resident party, of course, won't be ordered to post security for costs if they can establish that there are sufficient assets within the jurisdiction to protect or secure the defendant's cost entitlement. Corporate parties obviously have residency issues arise with regard to their status in litigation as well. The mere physical presence of a company or a business in Ontario does not constitute it as being a resident of Ontario. And so, again, in instances where you have corporate plaintiffs, you must move carefully to be sure that you tendered the kind of demand I've mentioned, and that you get satisfactory evidence that there's a real residency in Ontario and not simply an inactive office or a mailing address or something like that. I'm going to get to more details concerning this when I come to the issue of what constitutes a shell corporation or a nominal plaintiff. Foreign companies, again, can satisfy the requirement of residency if they have significant assets in the jurisdiction. And again, on these kind of motions, you will get into the filing and examining of affidavit material, financial information concerning the wherewithal of the plaintiff company and what assets are in fact within the jurisdiction and can be seized. The affidavit material and supporting material you would file as a plaintiff to respond to this kind of motion would have to be fairly detailed. In a minute I'll discuss it in further detail, but the case law seems to be going into the direction where you must give pretty hard evidence about what you have available. You can't simply say we have X dollars in the jurisdiction or we have certain kinds of assets. You must identify them with some particularity as if you were offering them up for payment, in fact, of any cost award. So the full details of the assets you say are in the jurisdiction must be included in the affidavit material, failing which you could lose on such a motion, and the court could conclude that it's uncertain as to what assets are available, and therefore the cost award is made against your client. One of the hotter areas, of course, is the whole question of impecuniosity, and Rule 5601 subparagraph D deals with the question of impecuniosity Now, you should note that the word impecuniosity doesn't appear in the rule, and at page 4 of the paper, there's a quote there from Justice Sutherland where he discusses what constitutes impecuniosity and what are the issues surrounding it so far as 5601D is concerned. The onus is on the plaintiff to demonstrate that it has no, he or she or it has no assets in Ontario, and if the, on the defendant, and if the plaintiff in turn though shows that they do have assets in Ontario, then an award would not be made. But if ultimately the plaintiff takes the opposite route and tries to show impecuniosity, then the question of whether or not it is just to award the security for cost order comes into issue. And that's where these cases get much more difficult to follow, and it's hard to find any particular precedent that will lead you to the appropriate answer. When you get into impecunious plaintiffs and whether or not an award of security for cost is going to be made, the court has to look then at the merits of the action. And looking at the merits of the action, of course, creates a strategic problem for the defense if they're applying for security for costs. Oftentimes, you apply for security for costs at the outset of the proceeding if it's quite clear that it's a foreign, non-resident plaintiff with no assets, and there's pretty certain evidence of that. But where you get into a situation where you expect that impecuniosity may become an issue in the course of trying to put forward the motion for security for costs, it would be prudent, and is often the best route to take, to do the discoveries first and get all the productions first, so that you can set the groundwork to try to show that there may not be a good case on the plaintiff's side, or that there may be problems with the merits of the case, and that could assist you as the defendant now overcoming the impecuniosity issue. And that gets into the whole concept of what is just, and that's what's referenced there by Justice Sutherland. As I said, with respect to impecunious parties, you can't simply give a vague description of what assets you don't have or you are missing. If a plaintiff is trying to prove he has assets in the jurisdiction and he's a non-resident, for example, cases have said that giving a certain amount as receivables owing to a company is insufficient. Particularity would be required. You'd have to give exact details of the types of receivables, who they are owing by, full particulars, just as in the context of a judgment debtor situation where you'd be looking to collect on those receivables. There is one case, and I won't bore you with quoting from a lot of cases here this morning, but there's one case which is cited in the material called Paul versus General Magnaplate. It's a decision of Justice Laforme in 1995. And in that case, again, I won't take you through the facts of the case, but he does make a comment that deals with the impecuniosity and the onus on a plaintiff. If a plaintiff is trying to assert impecuniosity as a response to a claim for security for costs, he says a plaintiff who claims impecuniosity, as the plaintiffs did here, has to do more than show poverty in order to be excused from an order for security for costs. It has to show that it lacks assets and that neither it nor its shareholders have the ability to borrow money, sell assets, or raise the money required to post the security in some other fashion. While the plaintiffs have demonstrated some degree of poverty, they have failed to establish that neither they nor their shareholders were able to raise the funds to post any security. So you can see from that kind of language, particularly in the context of a corporate plaintiff, the evidence filed in response to a security for cost motion has to be fairly cogent and detailed, and evidence of attempts at trying to raise security have to be provided as well. With respect to the shell corporation or versus the impecunious party, at page 6 of the paper, there's a quote from Justice Farley in a decision called the Better Business Bureau of Metropolitan Toronto versus Tuz. And in that case, Justice Farley stated as follows: "One should not confuse impecuniosity with impoverishment. There's no question that while the plaintiff is impecunious, it is not a shell corporation, brackets, functioning as a straw man in this litigation in the pejorative sense. Rather, it was and continues to be an operative entity of substance in the sense of a valid organization." So when you get into this whole question of whether it's a shell or impecunious, again, you get into fairly subtle distinctions. Clearly, if it's found to be a shell or nominal plaintiff with no real active business interest in the province of Ontario, the court will award security for costs. On the other hand, if it's an impecunious plaintiff, the court may, after having looked at the merits of the case, if the court is satisfied that the case is not devoid of merit at all, they may forgive the requirement of posting for security for costs if impecuniosity is led as a response. So you're going to see, when you review these cases, very subtle distinctions, and as I say, it's difficult when you take the cases and try to chart them out to find a trend. Every case, it's the same old rule that turns on the facts of every peculiar case or every particular fact situation. Another sort of important issue you got to keep in mind is even if a corporation that's non-resident does have assets in Ontario, if they're fluid or portable, liquid assets, obviously, they can easily be moved from the jurisdiction. If the court is provided with satisfactory evidence that that risk exists, a court could order that a security for cost order be made in order to protect the defendant's cost position. Another important area is where you have more than one plaintiff. If you have multiple plaintiffs in the action and say one of them resides out of the jurisdiction, if the causes of action being advanced by all these plaintiffs are joint, in that they all are working in a common interest, typically security for cost won't be ordered. But if there's several and they have unique causes of action, if a foreign plaintiff can't present opposite evidence to show they have sufficient assets or capability of paying a judgment and damages and costs, they will be required to post security for costs. Nominal Family Law Act claimants, for example, in personal injury litigation typically would not, of course, be asked to post security for costs because they have a joint interest with their co-plaintiffs, and similarly to their role in the litigation is nominal in the sense that usually the litigation is not extended substantially because of family law claimants in tort litigation. Counterclaims and third-party actions also give rise to claims for securities for costs. Often defendants unknowingly will institute counterclaims and all of a sudden face a claim for security for costs if they're a non-resident defendant. It's been held that if the counterclaim is so entwined with the main action, and secondly, the counterclaim will not lengthen or extend the proceedings to any great degree, the court again will forgive or refuse an order for security for costs in those circumstances. Security for costs, of course, can be awarded on appeals, and I won't take the time to go into those cases. They're cited in the material. Typically, it's in a case where the appeal is shown to be frivolous and vexatious, and again, the court on motion would have to be presented evidence to deal with the merits of the appeal. Towards the end of my paper, you will see a summary of security for cost provisions and other statutes. I won't take the time. We don't have time here today to deal with any of these, obviously, but various statutes such as the Public Authorities Protection Act, Libel and Slander, Municipal Elections Act, etc., have provisions in them, and you should be aware of that when you're involved in litigation or representing clients dealing with those statutes. Rule 5609 should be looked at. It's a general rule providing a very broad authority to award security for costs in many situations. It ties in with Rule 105, which is a rule that allows the court to set terms that are just when making orders. Obviously, if cases are in the midst of litigation and prior to trial, all kinds of orders or interlocutory proceedings are undertaken and orders are made. And in the context of those orders, the courts have the ability under Rule 5609 to make a whole variety of security for cost type orders. And you should take a moment to look at that rule as well. Timing for bringing the motion for security for costs, I touched on already. Typically, if you're certain that you have a non-resident plaintiff and there really won't be a contest over that, and you're pretty certain they have no assets, you should probably move as soon as possible because you want to get the biggest award in terms of costs up front so your costs before discovery are protected. If the merits of the case are going to be of concern, again, you likely have to wait to go through production and discovery, collect that kind of information, and then bring your motion. But obviously, the sooner you move in the process to get security for costs, the greater your costs are protected, assuming you're successful. Delay is another concern in the context of what I've been talking about. Unexplained delay on a motion for security for costs can be fatal. Again, I would recommend you look at the cases concerning that. You have the option, obviously, to move a second time after one award is made. The common practice, of course, is to move prior to trial. Once you've completed the first phase of an action, if you're going on to trial, you should move, if appropriate, to get more costs to cover the cost of the trial. I hope the paper I've presented is of value, and again, I recommend you look at the footnote material. It's quite exhaustive. Other reference material you may want to look at is Mark Orkin's book, Orkin on Costs, which is a very good book, quite up to date typically, with all the cost issues. And for precedent material, Williston and Rolls precedents will assist you in looking at the various kinds of affidavit material you need to put together a motion for security for costs, or similarly respond to a motion for security for costs. Thanks very much.
Thank you, Peter. Just a quick practical note. I was acting for a plaintiff on a security for cost case. I could see it was a pretty simple case, and I told my client, you're going to have to pay some security for costs, you're an American corporation, and it's going to be about X. Well, we went on the motion, and it was almost 3 times X. The defendant had the senior partner at the firm swear an affidavit. His hourly rate was, $400 an hour. He was personally going to be involved in this. Discoveries were going to take 5 to 7 days. He'd have to hire 2 experts at $5,000 each. I knew it was nonsense, but I had to wait till the end of examinations for discovery and then bring a motion to say that, their estimates had been way off and I could get my client some of its money back. In hindsight, maybe what I should have done is cross-examined on that affidavit, which really puffed up the extent of the litigation, so that it is, unfortunately, you can end up spending a lot of your client's money, but if you're not careful, as I wasn't, it can really affect whether they can continue with the litigation, because it can really be crippling if the defendant is successful in this tactic of this affidavit that this is the biggest case that's ever come to court, when it really isn't. Our next speaker can join us here at the podium. It's, sorry, could you put her to stand or sit? Okay, all right, we'll just do a quick shift while I introduce Mr. Sudhir Kakkar. Get near a microphone while I speak. He is a principal with the firm of KPMG Consulting, Inc. He's recently been appointed the project manager for the court component of the court's integrated justice project. He has over 25 years of experience in the field of information technology, most recently managing a multi-year, multidisciplinary system integration to automate the social assistance and welfare offices for the province of Ontario. He's here to talk to us today about the nuts and bolts of electronic filing, to, I guess, update you on some problems or some hints. And for those of you who haven't jumped on board, maybe he can explain what and how you do it.
Right. Thanks, Andrea. I have also invited my identical twin, Bill Vesey. He was the project manager for e-filing in Toronto for about 2 years and has got more experience on e-filing than I do. One other thing I wanted to clarify was that the introduction of this lecture series indicated that everybody is a trial lawyer and I'm not. So just wanted to clarify on that. What is e-filing? Electronic filing is a foundation building block of our e-access service. Integrated Justice Project, which I think is one of the largest justice modernization project in the world right now, e-access and e-filing are key components of that. What e-filing does is it will allow a service that will allow secure electronic filing of legal documents by the lawyers from their office for any court in Ontario. Some of the services which will be part of the e-access will include electronic access of the forms. It will include e-filing. It will also include electronic receipts and statements for financial reconciliation and disbursement, and the ability to search court filings electronically. In simple terms, what it means is that from the law firm, you will be able to log in on the web and access the forms electronically through Justice Portal, fill them up, and then send them out or transfer them to the court electronically too. How is it going to work? Basically, lawyers will be offered various electronic options. You will have the ability to file documents online via internet through the Justice Portal. We'll also offer the option of preparing documents in Word and WordPerfect templates, and those templates will be pre-designed by us, and then file them through a secure email by connecting to the web. In terms of the payments, there will be multiple options. One can make payments through credit card or otherwise through pre-authorized payments. At this moment, we have gone through identification of 28 most used forms in the civil procedures, and those are the ones we'll be offering in the initial set, and then we are converting the rest of the forms into electronic format, and we'll keep on adding to it, eventually covering each and every form. As a second part of the same e-filing process, we are also developing the e-access, which would allow the lawyers to be able to make inquiries in terms of their schedule and other things from the sustain database that we'll be putting on the back. These are just the nuts and bolts. It's not overly exciting. I tried to use some acronyms and terminologies to make it more exciting than the legal jargon. But if there are any questions, you can either keep them to later on or can ask now.
Well, I guess I don't even know how far you can go now with e-filing. You can file claims now by e-filing?
There's a Toronto e-filing pilot project, and what Sudhir is referring, and which you can actually file a statement of claim. And what we're introducing is the integrated justice solution, which replaces the Toronto e-filing pilot project. The main scope of the Toronto e-filing pilot project is civil pleadings, and that's the area that we're going to focus on first.
So you can now e-file your claim, and that's a pilot project
In
Toronto only.
And what we're doing is replacing that system with a web-based technology and making it available province-wide. We're starting a rollout to make it available province-wide.
Maybe what we will do is let Jeremy speak on mandatory mediation. Keep these two gentlemen here, and then we'll have the question period, and people can wander out and get coffee if they want, so we can sort of more or less stick to the schedule.
Okay.
That's
I was
okay?
just helping you to bring the schedule forward.
Thank you. Okay, our next speaker is Jeremy Solomon. He's with the firm of Reagan Samworth. He's called to the bar in 1988. His areas of practice, according to what he's given me, says bodily injury, accident benefits, and insurance coverage disputes. But I suggest this is generally on the defense side. You don't indicate this, but
yes.
of those kinds of claims. That's fair. He's spoken at a number of programs for the Advocate Society and the Law Society, so we're very fortunate to have him here today to speak on mandatory mediation, which, if you're sort of following along, we've got you to meeting your client, doing the claim, maybe e-filing it, to deciding about security for costs, and now mandatory mediation is becoming the next new step in our litigation process.
Thank you, Andrea. Probably one of the toughest things you're going to have to do when you meet with your client is try to explain mandatory mediation. Probably the greatest oxymoron that the legal profession is going to encounter in a long time. Mediation, by definition, I think we all know, is a voluntary process, and mandatory mediation flies in the face of that. And without getting into the reasons for it, our clients are going to have to understand what it's all about and we are all going to have to understand the distinctions between mandatory mediation and mediation in the normal course, and adjust the way in which we handle our files. Generally, though, I approach mandatory mediation in the same way that I do any mediation. However, I do keep in mind some of the problems that arise by virtue of the fact that the mandatory mediation takes place at a very early stage in the process, that it's not something that I feel the timing may necessarily be right, that I have enough of a knowledge base with respect to the file to be able to properly advise my client. There's a whole host of problems that you have to be able to deal with. Most importantly, we must proceed with mandatory mediation before conducting examinations for discovery, and that's probably the biggest difficulty that most counsel face, along with the fact that we haven't, generally speaking, secured all of the documentation that we normally would through requests made at discoveries. Consequently, counsel may not have a sufficient knowledge base to formulate an accurate theory of the case, nor to be able to assess the best alternative and the worst alternative for their client in the event that mediation does not succeed. In my view, probably the most important part of preparing a file for mediation, and this is whether or not it's mandatory, is the selection of the mediator. And this is something that most counsel really, I don't think, appreciate as much as we ought to. The problems are heightened with mandatory mediation because we're given a roster of mediators that are available to do this type of work. It is true that we can depart from the roster, but that's not a very easy thing to do because the mediations have to take place within 90 days of the first defense being filed, and anybody who has been involved in voluntary mediation knows how difficult it is to get a mediator booked in such a short time frame. The roster of mediators will probably comprise of people that none of us have ever heard of or rarely use in the ordinary course of mediations. So we're dealing with a lot of unknowns, and that is quite a frightening thought when you're dealing with mediation. In my experience, the quality of the mediation usually corresponds with the selection of the mediator. Therefore, the selection must be made on an educated basis as far as best as possible. Mediators, that we all have to understand, mediators do have unique styles and approaches which may or may not suit an individual case. For example, does the mediator follow a facilitative or an evaluative approach? And we have to understand the differences between those two. Does the mediator thrash or bash the parties or hash it out with them? And you'll see at the end of my paper, I describe a little bit what those terms mean, so I won't get into it now. Mediators, something that our clients have to understand, are great manipulators. That's what they do, and they have to be able to do that in order to pierce the egos involved in litigation, the egos of the parties and the egos of the lawyers, and they have to be able to manipulate the information they receive in order to try and get the parties together to reach an agreement. So having that in mind, my recommendation is that all parties, once you are aware that your case is going to be case managed and you are going to be thrust into the mandatory mediation system, should get together and agree to conduct a telephone conference with prospective mediators and find out what the mediators are about, who they are, and make an educated and informed decision as to who you want. Some of the things that you are going to want to canvass with prospective mediators is, first of all, do they have a conflict of interest? You want to know what sort of process, format, or mechanics the mediator utilizes during the course of mediation. What is the mediator's business and educational experience? If the mediator is a lawyer, and quite a few on the roster are, you want to know what specialty does that lawyer practice in, and do they usually represent plaintiffs or defendants? You want to know how does the mediator respond to power imbalances? And there are generally two different types of power imbalances. One pertaining to the parties themselves, and you often see that in family disputes, for example. The other power imbalance is counsel. You often have a situation where you have very senior counsel on one side and very junior counsel on the other. Is the mediator willing to offer an evaluation if requested? That's sometimes something that parties would like to hear at some point in the mediation, but not always. What strategies does the mediator use to resolve an impasse between the parties? You want to know how creative the mediator is in resolving impasses that seem insurmountable. How does the mediator view the role of counsel versus the parties? And this is quite an important factor. Some mediators want the parties to do as much of the talking as possible. Others would prefer to hear from counsel. And that is an important decision that counsel has to make, because you know how effective your client is going to be at communicating his or her position. Probably the most important factor is what is the mediator's policy on maintaining confidences. And I'll come back to that in a moment. And lastly, one of the factors that you'd want to discuss with the mediator is she willing to continue beyond the allotted time and at what cost? And I'm sure you probably all know that under the mandatory mediation regime, there is a 3-hour time limit, but the rules do provide for the parties to extend beyond that. However, you have to individually contract with the mediator what the fee is. So that's something that you'll want to discuss in advance. I pay particular attention to the style of the mediator, whether it's facilitative or evaluative, and the approach taken with respect to confidential information. This latter point, I think, is of particular concern. Some mediators say they will not disclose confidential mediation, but through their actions and language, the essence of the confidence is often revealed. I generally err on the side of not disclosing confidential information, even if I feel the mediator may benefit from having that information. And I particularly take that approach where I have limited experience with the mediator, and I really don't know how they approach confidential information, and also if the mediation is mandatory and prior to discoveries. Because if the mediation fails, I don't want my opponent to have information that I can use as a tactic at discoveries. Dealing with preparing the client, I think first and foremost, we as lawyers have to explain what mandatory mediation is all about and why it must be exercised in good faith. There is one case that I'm aware of that very briefly touches on the issue of good faith. It doesn't define what good faith is, but it does suggest that good faith bargaining is something that must be exercised during mandatory mediation. And that is a case called Martins versus Ali, and it's a decision of Master McLeod. I believe it's dated December the 17th, 1999. It's particularly important to discuss concerns about confidential information and the need to exercise caution during private caucus to ensure that such information is not revealed at too early a stage in litigation. If mandatory mediation fails, the client should be told that they should not become emotional or take an intransigent position. The client should understand that mediation, generally speaking, is premised on a mutual agreement to discuss settlement at the right time with a mutually agreeable mediator. The client should understand that the mandatory nature of this process may in fact be the reason why settlement is not reached. The client should also be made aware of the process, and the decision should be made with respect to the active involvement of the client. And that comes back to when I talked about how does the mediator view the role of counsel versus the role of the parties. If you have a mediator that wants to hear primarily from the parties, you have to assess your client's ability to communicate his or her position. The client should understand the basic dynamic of caucusing, explain to the client that different mediators approach caucusing with unique styles. Hopefully through your initial interview with the prospective mediator, you will be able to anticipate the style that will be utilized by the mediator, and generally the style will either be facilitative or evaluative. You should explain how the mediator will handle confidential information and advise your client that if there is any doubt about that, do not disclose the information. Counsel should obtain instructions in advance to continue the mediation beyond the mandatory 3-hour time limit if the parties choose. This, again, will involve prior discussions with the mediator about his or her fees. I find that there is a very unique problem that arises with respect to corporate clients, and that is the selection of the most appropriate representative of your client. Some of the indicia that I have come up with in selecting the appropriate person includes objectivity, composure, probably most importantly, effective communicator, knowledgeable with respect to the facts and the issues, somebody who has full authority to settle. And please note that the rules do speak to authority to settle. While you may not necessarily have a representative who has the final authority, the person who has final authority must at all times be available by phone, and the representative must have patience. In preparing your client, you must review the strengths and weaknesses of both sides of the case, and you must assess what is the buzzword BATNA, which is your best alternative to a negotiated agreement. And one of the things that clients often say is, well, we'll just go to trial, and that's fine, and we're going to win at trial. But you have to remind your clients that there can only be one winner at trial, whereas mediation, there may be two winners, depending on how you look at things. You have to take an objective analysis of what is likely to happen at trial. You have to assess as well indirect ramifications of litigation, such as unrecoverable legal fees, emotional stress, loss of time from business and personal activities, and loss of beneficial relationships with the opposing party. Counsel should also review with his or her client what their interests and goals are. We as lawyers often get caught up in legal rights and lose sight of the fact that clients often have interests that go well beyond what their legal rights may be. You may find, for example, that you have a client who is less interested in a favorable monetary award in exchange for continued relations with the other party. You may also find that you have a client that cannot withstand the emotions that go along with protracted litigation. And these are all things that all of us, I think, have a duty to understand and appreciate. And above all, we have to understand that the quality of the result is in the eye of the client. And I know that there are litigators who disagree with me on that point, and it's very easy to stand back and say, well, I could have done a better job for this client. I would have achieved a better result. But we as counsel for the client are the only ones who really understand what our client wants. And it's our job to represent our client, not to stand back and say, analyzing legal rights and principles, what is the best result? Preparation of counsel. I think it's important to understand that there are generally two distinct negotiation styles. There's a cooperative style and an aggressive style. I don't believe that one is better than the other, although statistics generally do show that the aggressive style tends to result in more favorable, depending on how you assess what favorable means, results for clients. In my view, style ought to flow naturally. You can't be somebody that you're not, generally speaking. It's the same principle that applies for conducting a trial. However, an effective negotiator should have the ability to change styles when appropriate. A good example of that is that cooperative negotiators have to have the ability to be able to stand back and become more aggressive when they find that they are being taken advantage of during the negotiation process, and to become somewhat more aggressive should the need arise. Now, I think there's a misunderstanding as to what aggressive negotiating tactics are. To some people, aggression is being rude, nasty, belligerent. And generally speaking, I find that when I come across an opponent who takes that approach, it's usually because they're not prepared, and it's a mask for being ill-prepared. In my view, being aggressive is taking a firm position, and you don't have to do that and at the same time be rude and obnoxious. And I think that's the sort of aggressive approach that I would recommend as opposed to the obnoxious approach. Whether you're aggressive or cooperative, there's no substitute for understanding all of the factual and legal issues in the case. And this is really one of the giant pitfalls of mandatory mediation because it happens so soon in the process. Nonetheless, we have an obligation to fully analyze whatever facts are available to us in advance of the mediation, and at a minimum, counsel have to obtain a sworn affidavit of documents. It's true that we're not going to have all of the documents that we want. We're not going to have discoveries, but if we don't, at a minimum, get a sworn affidavit of documents and all of the productions that go along with it, then we're not doing our job. Lastly, I just want to end off with an anecdote. Even though you fully prepare yourself and your client a week or two before the mediation, take some time in the day or two before the mediation to review the case with your client, along with the negotiation strategy and the instructions that you have already received. This will help reduce the risk of your client taking you by surprise on the day of the mediation and telling you that they have changed their mind with respect to their settlement instructions, which will significantly alter your approach to the mediation. Now that's the short form version of the paper that I've got in the materials. I would like to bring just two cases to your attention, and I believe you can obtain copies of some of these cases through the Alternative Dispute Resolution section of the CBAO. There are two cases that were decided by Master Palika, and those two cases dealt with a consent motion to extend the time for mandatory mediation. In both cases, the master rejected the request, and he did so because the basis of the request was that discoveries had not taken place, the issues seemed to be complicated, and counsel felt that mediation prior to the discovery would not be fruitful. The master did not find that to be a persuasive argument. He noted that the rules for mandatory mediation make it almost of necessity that the mediation will take place before the discovery process, and the purpose of that is to save costs. So you're not going to succeed with a motion to extend the time by saying we need a discovery. You're going to have far more persuasive evidence to convince the masters that the time ought to be abridged. The cases that you'll want to pull up, I believe one of them is called Peel Condominium Corporation versus Law Development, and I don't have a citation for that, but again, I think you can probably get it through the CBAO. The decision was rendered on November the 3rd, 1999. The second case is Rokicka, R-O-K-I-C-K-A, versus Peter Metchel, M-E-C-H-E-L, et al. And that decision was released on January the 26th, 2000. And actually, I think there maybe one other. I just want to take a look here. I think there's another one called Rolfe, R-O-L-F-E versus O'Day, dated Monday, February 21st, 2000. So those are a couple of cases that you may want to take a look at. Master Palika sets out in his view the criteria for abridging or not abridging the time, and I think those may be of some assistance to you.
To just add 2 quick points to what Jeremy said, those 90 days sneak up on you very fast, and it's 90 days from when the first defense is filed, and we're really not doing a job for our clients if we just sort of sit back and, you know, someone's automatically appointed. You may get somebody who's really inappropriate for your case, and I think we all have to network and get to know these people and their strengths and weaknesses, who's good for what kind of case. It was a little intimidating when it started. You got this list of pages and pages of people. As Jeremy said, I knew about 5 of them, but those 5 people, everybody else knew too, and they were always busy. But I think it's what you really have to ask your friends and colleagues who they've had mediations with, which have been good, so that you don't just take whoever comes up in the roster and gets assigned to you. And my other thing that drives me crazy, I have a lot of clients who don't have a lot of money, and this is just one more disbursement. And not only is there the set fee, but they're also starting to charge you for the room. And so what I have done is suggest that we either do it at the other lawyer's office or my lawyer's office, my office, and most mediators are okay with that because there's usually a fee of about $150 to rent the room because the mediators don't have their own space. It's just another hidden cost, so most people are pretty good about that, so that the fee is for their time, but then they're also allowed to charge whatever off due, whatever rent they have to
pay for the location that's been selected. I've had mediators from Barrie, and so they have no place in Toronto, so they tell me there'll be another $200 charge on top. So there are ways around that if the council will cooperate. Why don't we do a few questions? I know there was a gentleman in blue back there had his hand up.
That's, you're referring to the Toronto e-filing pilot project. That is in fact true. The rules were normalized. In other words, they were amended to extend an invitation to other law firms to participate in the Toronto area for the Toronto courthouse. And the project that we're referring to will be the implementation of the IJ project, and we'll obviously build on that.
So is it now the case that anyone can apply to become part of this project and file this in Toronto?
That's correct.
So it's not a closed
No,
project, it's still open.
That's right.
When do you expect that project to end, and will you take
We're finalizing, the project will never end. The Toronto e-filing pilot rules, or the Toronto e-filing rules are the rules that will be adopted and used for the IJP solution. What will happen is the technology that's used currently in the pilot project will be replaced with the IJP's technology, which is a web-based solution as opposed to an proprietary email-based solution.
And when do you expect that?
We're currently looking at a schedule right now.
Do you have any ideas? We're talking 6 months, 2 years.
Somewhere in that range. Well, I'm glad you didn't. Just to explain a bit, basically the simpler the front end we make, and this is being made into a very, very simple front end, the more complex the back end becomes in terms of the technology and the logic and everything else that we have to put in, which means it requires extensive testing. And right now we are going through a bit of a design and testing phase. We'll have a probably more comfortable position to answer on in a couple of months' time as to when it's going out into the production. And that's the reason I wasn't able to confirm the timing as yet. I wasn't being frivolous about it.
Are there any other questions? Some of the speakers, 2 of them just walked out, but I see Lois is still here. Yes.
I don't see why you wouldn't.
Yeah, I don't think there's anything that changes. You just didn't have to send somebody down to the courthouse.
Right. E-filing is the only mechanism that you file.
That was sort of the same question as the other gentleman. That's going to come in with the 28 forms, and that's at least 6 months away, and maybe longer, from what I heard.
Yeah, the focus initially will be on the pleadings, and we're looking at layering in some of the documents which arise from the trial phase of the case later.
Yes.
Question for Jeremy. Jeremy, in your paper, you indicate that mandatory mediation as is currently regulated.
Well, it's in the rules of civil procedure. Rule 24.1 is where they've set out the procedure, and I guess what I refer to as the current regulations for mandatory mediation. Something that everybody really ought to take a look at least familiarize themselves with the time frames, because those are very important.